Got everybody in.
Good morning, Judge, or afternoon. I have Mr.
Good.
Holler present in my office. He's just off camera.
Okay, thank you. And that was Ms. Danke for Mr. Holler. Can I have everyone else identify themselves for the record?
That way, prosecutor's office.
Patricia McGuire, I'm the worker for VALA from DHS.
Ivan Brown, LJAL.
Well, and I got somebody on a Galaxy that just logged in. Let me get them in.
You know who Jackie Johnson is?
All right, and Jackie
Oh,
Johnson has
another
just
worker.
appeared.
I recognize her now.
And as soon as I have a connection with the Galaxy, we will proceed.
I think I've ever talked to Jackie Johnson.
She's a supervisor.
She may have been over at the family team meeting when we did it. I just can't remember.
So Ms. Danke, you're looking a little bit like a hologram. You're kind of fading in and out of your virtual background. It's kind of a funny.
I can.
It doesn't matter.
Good
I was
enough.
just amused more than anything.
We'll see if that makes it better. It's more peaceful anyway.
It is.
It just helps prevent all the stuff that goes on in the back of my office from showing up on the screen.
Okay, I'm
The internet is
still
definitely not
struggling
good.
with the Galaxy, but someone just logged in on the 416 telephone exchange. What's your name, please? Telephone number 416-9271. What is your name?
I'm Janine Green. Can you hear me?
We can now.
I was muted.
Judge, can you tell us who that is? This is kind of a sensitive case.
Does
I
anyone
am
else recognize it?
basically. Can you all hear me? My name is Janine Green, and I have Anna
Janine?
and Selena.
I think she's here on the,
I-
and I think Ms. Johnson might be here. She must not have seen my email on the
Oh.
Conan matter. We handled it this morning, actually. The
Oh,
father
okay.
entered a plea.
Okay. Oh,
Yep.
so Janine, you and I don't need to be here. Okay.
Okay,
Okay, good.
thank you.
Okay. So this is a matter of Bella Holler Jackson and Mr. Way. You have a couple of motions you wish the court to address.
Yes, Your Honor. I did speak with Ms. Danke late morning. She informed me that she is okay with pretty much all of my requests except for preventing Vala to from testifying in person. So I'll just address that. We might need to address specifics depending on what the court does in regards to Vala testifying. I was not at the previous, I think it was a pretrial. I've heard some of the discussion. I was told that I think there was a parallel drawn between this evidentiary hearing coming up and a preliminary exam, like in a criminal hearing. And I think there's a couple important distinctions to note regarding those two. Number one, the preliminary exam is a lot like the preliminary hearing in a case like this, in an abuse and neglect case or a trial in either sort of case, where the purpose of that is to protect the rights of the person accused of a crime or abuse and neglect. There was an opportunity to force Vala to testify at a preliminary hearing. That that all was waived. I don't believe even suspended parenting time was really challenged at either the 24-hour hearing or the preliminary exam or the preliminary hearing to the best of my recollection, and I could be mistaken. The purpose of best interest, the purpose of parenting time determinations, especially in a case like this, where this is a termination petition and Mr. Holler is not entitled parenting time. That's completely up to the court's discretion. It doesn't have to make any additional findings regarding harm to the child. So this is what this essentially is a best interest hearing. It's far different than a preliminary exam or preliminary hearing or any sort of trial. And I think given that we should be acting in Vala's best interest, and I believe it's in Vala's best interest to not have to testify, especially because we have another option in this case. We have a forensic interview. If the court were to view the forensic interview and to deem that wasn't sufficient enough, we could always readdress it at that point. We do have a forensic interview done according to the Michigan interview or forensic interviewing protocol. It's been provided to all parties. And at an evidentiary hearing, the rules of evidence do not apply. They do apply at a preliminary exam. They do apply at any sort of trial. There are some exceptions in a preliminary exam, but this certainly wouldn't be one of them. So I think with that option for the court to hear and view her forensic interview, I don't see any purpose behind Vala testifying other than to potentially traumatize her further. So we do also have a therapist that I intended to call it the evidentiary hearing, regardless of what the court decides. I've provided that letter to all parties. She believes that it's in Vala's best interest to not be visiting with him. So I'm asking that the court basically just at the evidentiary hearing view this forensic interview. If not, I am asking for all the accommodations that I put forth, including appointing a third party, whether it be Mr. Brown or Mr. Hotchkiss or Mr. Kelly, somebody else to question Vala, so we can get the most objective and least embarrassing testimony out of her possible. Thank you.
And so before Ms. Denke responds, let me say what I was trying to do here is balance the father's right to a jury trial with all the other dynamics in a neglect and abuse case, and recognizing that we cannot do a jury trial, and yet without the court hearing any evidence, it looks like many, many months would take place before the court would get an opportunity to hear evidence. So I realize we're in kind of uncharted territory here, but on the other hand, it wasn't the court's desire to victimize the young child. So with that comment, Ms. Denke, go ahead with your position.
Thank you, Your Honor. As the court has already alluded, there are normally very strict timeframes by which trials have to be accomplished, even when someone does assert their right to a jury trial. These cases normally move very, very quickly. In this case, we're probably looking at a 9-month delay from the last time my client saw his daughter to when we're actually going to be able to go to a jury trial. I understand Mr. Way's desire to just have the court watch the interview that was conducted. I think Judge, you don't have the ability to judge the witness's credibility by watching that. On the other hand, as I've already stipulated, I'm fine with taking a number of measures to try and minimize this child's distress, but I think it's a very different situation sitting in a room at the CAC talking to a psychologist to actually talking to a judge. I think there is, even for children, a much greater understanding of how serious this is and the need to tell the truth and to answer questions, some questions that were not asked of her, because the person doing the interview didn't have any background as to what had been going on in the family. I'm fine with having a third person do the questioning. I would just like to be able to submit a few questions to them. And I don't care if they restate or rephrase the questions, but there are some areas that I think are appropriate to be explored. I think for the court to completely suspend my client's parenting rights for 9 months without taking some additional step would not be appropriate. My client can participate by video, and it can just be that screen of, a silhouette rather than his presence there. His microphone can be muted, so the court doesn't have to worry. He might say something that Vala could hear. We have no objection to the support person. We have no objection to her testifying by video if the court wanted her to testify by video, as long as she and the support person that the prosecutor has named are the only ones in the room. Because that's always the challenge when they testify by video. You can't see someone else sitting off camera and what they're doing. But given the support person they've chosen, we don't have a concern with that. So I think the court can make a number of efforts to minimize any trauma, but I think for the court to make any real decision based on credibility, I think you need to be able to actually hear what she has to say. I recognize this is not a criminal case, but if the prosecutor had charged this case criminally, she'd be testifying in a preliminary exam and trial and this hearing or this trial. And they do that routinely, where they put the kids on the stand a lot. Our hope is to try and minimize this, but that's where we are at this point. Thank you, Judge.
Mr. Brown?
Judge, the only issue we're having a evidentiary hearing is because DHS wants to move her in with her aunt who has adopted her siblings in Tennessee. ICPC has been approved. The court suspended parenting time. It's been suspended for quite some period of time. But for the request to move to Tennessee, I don't think we would ever be having this hearing to try to reinstate parenting time. So whether it's 700 miles away in Tennessee or 30 miles away here in Jackson, I really don't see the difference. I think the court, from viewing a CAC interview, is perceptive enough to understand body language, things that don't quite compute when, if Valhalla is giving her testimony to the CAC interviewer. The court's quite perceptive, and if the court has issues with her credibility, I'm sure you'll pick right up on them. Further, with allegations like these, I'm a little confused that if allegations, even if they're not true and made by a child, and I consider allegations such as these probably more significant than murder. They're abhorrent, and I can't quite understand. I know Mr. Holler, in some form or fashion, Jackson probably loves his daughter, in whatever way that may be. But why a parent would want to put themselves in that position again if her testimony he feels is false? I think the court can get a feeling from the therapist and viewing the testimony whether she should be with her aunt in Tennessee or not and continue suspending parenting time. Thank you. And with regard to if the court's going to go the way of having a third party question, I don't feel that should be the guardian ad litem who is trying to look out for her best interest. I am trying to develop a relationship with her that may last quite a long time. And if I have to be the one to answer these or ask her these questions, I don't think that's appropriate. Thank you.
And so I'm assuming each of you attorneys has had a chance to view this video of the CAC?
Yes, Your Honor.
I have. I don't know that Mr. Brown has.
He hasn't.
I mean, one possibility is before I decide whether I'm going to make her testify again, I view that and see if there are any lingering doubts in my own mind. I would even be willing to consider, as I view that, whatever questions, Ms. Danke, you'd like to pose, so that as she's being questioned, I have some ability to judge, well, had these questions been asked, could they indeed have an impact on a testimony? I don't want to force you to do that ahead of time, but if my inclination is to watch the CAC myself first before I make any decision as to whether I'm going to make her testify prior to a trial. I want to get some comfort level beyond allegations. That's and the best interest of the child are certainly utmost in my consideration, but I have to think about a dad who's been completely innocent, falsely accused, and now, other than give up his right to a jury trial, is left essentially without a remedy between now and when we can actually do a trial.
So we can certainly arrange that, Your Honor. We don't put our interviews on CDs anymore. We have like a cloud system, but I can, I don't know if you want to do it in 2 weeks where everyone can view it as well. I mean, I can play it via the cloud system. Ms. Danke has that same access.
If everyone else has had a chance to see it, and Mr. Brown could certainly be given that opportunity, is there any reason I can't just review it in camera? I mean, I don't have to do that on the record, do I?
I have no objection to that, Your Honor.
I have no objection. We just have to, I mean, I can actually probably just lend you my laptop, because you have to, it goes through a process that you have to create an account. So, but we can certainly arrange for you to do that. I obviously wouldn't be present, but we can arrange that for sure.
All right.
And if,
go ahead.
If the court gives me a date by which you expect to be watching it, I can submit to the court and the other parties. I don't know if it's exactly questions that I would ask the witness or just areas to explore, issues to address, kind of a thing. But I can give the court something in writing to the other parties as well about those things that are not addressed specifically in the CAC that I would like to be able to inquire into.
Right, and I guess what I'm looking at is, she's what, 10, 11 years old?
Just turned 11.
Just turned 11, Judge.
Just turned 11. Certainly what the court would want to be able to consider is why would a 10-year-old, I guess she was 10 when she had the CAC, or when she first made the allegations?
She was 11.
Why would she make up such horrible things against her father? And that's what I have to balance. Certainly I judge credibility just by observing her responses, demeanor, but what could cause a child to make such horrible allegations against someone she loves and has lived with for all of her life? Why would a child do that? So anything that would give me reason to question the credibility. I know sometimes that usually what we see in this kind of a situation is it's not a child, it's a stepchild, and we got a stepchild that doesn't like the stepfather and wants a way to get out of having to deal with him. We don't have that here. We've got a natural father. So what else? Has she been influenced by somebody to coax her to do this? And even then, what could possibly cause a child to want to make up such horrible allegations against a natural parent? So anything you can give me to consider that perspective before I view this, I think would be helpful to me. So, as it turns out, I don't have anything on my docket tomorrow, but I realize that doesn't give you much time, Ms. Denke. Let me take a look ahead and see what my schedule looks like coming up. I'm assuming you're going to want at least a few days, maybe as much as a week, Ms. Denke?
Yes, please. Just because whatever I'm going to be submitting to you, I want to make sure my client has a chance to review as well.
Okay, so let me take a peek.
But
Yeah,
I'm
what my
not writing a whole brief or anything, so it doesn't have to be way out now.
Okay. Definitely, I could have time, assuming Matt's available, to get me his laptop next Monday afternoon. I've got a motion hearing at 1, so I'll say by 3 o'clock. That would work. Oh, wait a minute. 3 o'clock should work.
So would it work for the court if I had it to you prior to noon on Monday, or do you want it by Friday?
No, that would be fine. Noon Monday would be fine. And then Matt, if we can arrange sometime that afternoon for you to get your laptop up here so I can watch this thing.
Yep. I will make sure that either myself or someone else comes up and allows you to watch.
All right. And then after I view it, I will decide whether I want to take further arguments, or maybe I'll just simply issue a ruling based on what I see.
Thank you, Judge.
Thank you, Judge.
Thank you. Thank you. Have a good day, everyone.